The Department of Justice under Jeff Sessions reversing its position on Texas's controversial voter ID law after siding with civil and voting rights organizations for the past 6 years. Well, the Obama Department of Justice did, not Jeff Sessions. Today, DOJ lawyers plan to inform a federal district court in Texas that the government is abandoning its argument that the law was designed with the intent to discriminate against blacks and other minorities. Although the law was enacted in 2011, a federal appeals court blocked its full implementation during last year's presidential election after ruling that the law had a discriminatory effect. But the appeals court left the question of whether the law was intended to discriminate against minority voters to the lower district court. The bottom line is that this is the first major voting rights case for the Justice Department under Jeff Sessions. The DOJ is no longer fighting laws that violate the Voting Rights Act. Joining us to break this all down, Danielle Lang, Deputy Director of Voting Right for the Campaign Legal Center, one of the organizations fighting the Texas voter ID law in court. So here we have Jeff Sessions, who was held up as the beacon of light when it came to civil rights, as somebody who advanced and protected the rights of voters in Alabama, which we all knew was a lie when it came out of his mouth. And here's one of his first actions when it comes to the discriminatory Texas voter ID law.
Absolutely. And I think that you make a really good point, which is that, yes, he was held up as a beacon of civil rights. But at the same time, every single major civil rights organization was warning Congress that this was unacceptable. So while it's true that the Trump administration tried to hold him out as a civil rights beacon, we all knew that wasn't true. And in fact, the director of voting rights at Campaign Legal Center was at the Department of Justice when Jeff Sessions was there, and he was the one working on the cases that Jeff Sessions listed on his questionnaire as civil rights cases that he worked on. And he introduced testimony in front of the Senate Judiciary Committee saying these were not Jeff Sessions cases. Jeff Sessions did not work on these cases, so we knew what was coming. That being said, after 6 years, almost 6 years of the Department of Justice saying that this law on the facts was intended to discriminate against minority voters, put away what actually happened, which was a huge discriminatory effect, that it was intended to do so. No facts have changed, and yet the Department of Justice is going to stand in front of a federal district court judge today and say they're dismissing their claim, giving up the claim.
Gianno, thoughts?
Well, my thoughts are, in this particular situation, and this, from my view, I do believe that there was maybe not an intent, because I don't know what the intent was to discriminate, but when I look at areas where you have to drive 100 miles away to get an ID, I know that there is a level that discriminates against individuals. I get. I'm not saying there's an intention there.
But putting that in the law was intentional. And the root word intentional is intent.
But that does not mean that they said per the law you got to drive 100 miles away. That says that there wasn't enough resources allocated so people could get ID.
I'm sorry. Go ahead.
They were informed that this was the case. There were legislators in the debates saying, Wendy Davis explaining that this would harm minorities, that minorities would not be able to get IDs. They had numerous amendments. So part of the case and part of what the courts have relied on to find, and the district court relied on, was that
what we're seeing is we find some agreement where I'm saying it's inappropriate. They should have provided resources so folks wouldn't have to drive 100 miles away to get an ID. So yes, that would disenfranchise people. I get that 100%.
Gianno.
Another element of the case, which was the ID part. So people had a problem with the fact that students could not use their student ID to vote, which I find to be problematic on many levels, because they've used an example of you can use your gun license to vote, but you can't use your student ID. Well, we know that with your student ID, there could be a student that's actually printing the ID. The student IDs can be manipulated, and gun registrations are issued by the state.
Let me help you.
There's difference.
Can you please stop? I am from Texas.
Right.
I am born and raised in Texas.
Right.
The law in Texas was you could not even use a state issued ID from a state university. You can't sit here and print an ID from Texas A&M. Do you know why? There's a barcode on the back. It's state issued ID.
So you're saying that it can't be manipulated at all?
Texas A&M University is a state university.
So you're saying it can't be manipulated
Well, guess what? Would that be the logic? A driver's license can manipulate it?
driver license can be manipulated, but not in the same way in which a college ID.
You
The
clearly
systems in
don't
which
know
they
the
use are
IDs
different.
used in Texas. I do,
point out-
because I had one.
Okay, that's
Go ahead, I'm
fine.
sorry, go
No,
ahead.
that's quite all right. But so to point out that it was on the record that legislators said that they had absolutely no reason to believe that student IDs were being used in a fraudulent manner to vote. So the question is, what
On the
evidence was
record.
before the legislators? And the legislators could not explain why they rejected amendment after amendment that Wendy Davis and other legislators said would help minorities, and they rejected every single one. And on that record, the district court found discriminatory intent, and that issue is once again before the district court, and unfortunately the Department of Justice is not interested anymore.
Monique.
Right, and the thing that to me is critical here is that sometimes people don't know that the threshold is necessary. It's not just enough to show that there's discriminatory effect. We have to go the next step and show that that was the intent, and we look at the legislative history, as she just finished saying. But what we have to do now, organizations like yours, like an AACP Legal Defense Fund, look, folks, they need money. They need support, because this case doesn't disappear when our federal government drops us. There are still other organizations who are bringing suits on behalf of people of color, and we need to support those organizations and the lawyers that are doing that work.
Danielle, we appreciate it. Thank you so very much.
Thank you.
A peaceful protest turned deadly. 37-year-old black man was shot and killed by Baton Rouge police. Your hands are in the air, and you still get shot by the cops.
Oh my God, please don't tell me he's dead.
We're not going to let hate define us.
Race is a big part of this.
If truly all lives matter, then all lives need to matter equally.
What we require is action. What we require is accountability. We understand that black lives do matter, and we will keep focused on this issue.
NewsOne Now, every weekday morning at 7 on TV1.